Welcome to this edition of Council Update. I'm Councilmember Steve Dennis. Cottage Grove is a vibrant and growing community, and you can see this virtually everywhere you go, whether in our industrial business park, retail and commercial centers, or new residential housing developments. Cottage Grove is a place where people want to live and do business. The good news coming from this growth is our tax base continues to increase, which in turn helps to offset and lower the portion of taxes we pay individually to run the city's business. This aids us in delivering the tremendous service to our residents that people have come to expect, while increasing overall value to our community. When it comes to residential growth, what we've experienced is market-driven, and many land and property owners within the city are taking advantage of current conditions by selling to developers. These are private sector deals that happen between willing sellers and willing buyers. They're conducted independent from the city, and to be clear, are not something we recruit for. Today, I'd like to talk a little bit about the development process, which is legally complex, but from a city's perspective is pretty simple. In essence, when a residential or commercial developer enters into an agreement with a land or property owner, and their plan meets current zoning requirements or future land use designations, the city staff, volunteer commissioners, and elected council members are required to work within the confines of law to address the project. So today, I've asked our City Attorney Kori Land to talk a little bit about what the city can or can't do when it comes to handling these types of developments. Welcome, Kori.
Thank you. Thanks for inviting me.
Kori, tell us a little bit about the process. What happens after a landowner and developer enter into an agreement? Does the city have much discretion in these agreements, and what is the city's role?
That's an interesting question. Thanks for that. A private landowner deal between a private property owner and a developer is a private contract, and the city is not a party to it and can't interfere with that contract. What typically happens in those purchase agreements, though, is that a developer will have what's called a contingency, that they must receive certain entitlements before they will move forward to closing on the property. And that's where the city gets involved, because those entitlements usually require an application to the city. And so that's when the city can step to the table.
What happens when a proposal comes forward that doesn't meet the zoning or land use requirements?
When a developer submits an application, the city then applies its rules. We have zoning ordinances, we have a comp plan that plans out for that particular property, as well as subdivision regulations. So the city will take an application and see if it meets all of its rules and regulations. And when it doesn't, they try to encourage the developer to come in with a plan that does. And so they will try to get it to meet the four corners, what I call, of our books. And if the developer needs a variance, they can apply for that. Doesn't mean they are entitled to it. They have to meet certain elements of a test to get an exception to our rules. And if the developer still insists on submitting an application without a variance and that doesn't meet the code, then they run the risk of it being denied. And if it's denied, the city must have findings of fact for denial, which include it's not consistent with the comp plan, or it's not consistent with the zoning ordinance or subdivision regulations, or it will injure or detrimentally impact surrounding properties or the community as a whole. And so when the council has to take the findings of fact into consideration, they must look at all the evidence that was presented, and it can't be based on speculation. It can't be based on people who oppose the application or who are not fond of the application. It must be based on fact.
Kori, we often turn to you for advice through the approval process because the city needs to protect itself from potentially legal, costly ramifications regarding the approvals we make. Tell us more about this area of law.
Land use law is very complicated, and it is potentially fraught with minefields that we need to make sure the city avoids. Property rights are protected by the U.S. Constitution, by the Minnesota State Constitution. So we have adopted certain rules and regulations that then take those mandates into consideration to make sure that property owners' rights are protected as well as the city's rights are protected. Property owners look to our ordinance to see when they want to do a development project, how they can do it. Then the city is obligated to follow those rules when they take those applications into consideration. So we must adopt appropriate findings, whether it's for approval or denial, and make sure that we're following our process, because failure for the city to do exactly what they need to do according to their code and their ordinances could subject the city to legal ramifications or to subject the city to liability from a property owner. Again, they're entitled to rely on our ordinances and our rules, and where we deviate from that, we face the consequences, which can be completely unknown when you get into litigation. We don't know what a court's going to do. We do know that it's costly, and the outcome may not be what's in the best interest of the city.
How can adjacent property owners provide input throughout the process?
The city ordinances require, and state law actually requires, a public hearing. And a public hearing means that is the place where all the evidence can be presented, where the Planning Commission and Council can actually hear all of the information they need to hear to make an informed decision. The city sends out notices in advance to property owners within 500 feet of the application. It goes out into the official newspaper for the city, and it's also posted on the website. So anybody can come to a meeting and let the council or the Planning Commission hear from their own perspective, their interpretation of the application, how it affects them, and what information that they think that the Planning Commission and Council need to know to make an informed decision. A lot of those things can be taken into account. Speculation, as I indicated before, is not a good finding of fact for the council to rely on, but fact is. And some of those things, it's valuable input that the city can receive from these property owners who will live next door to this application, because then the council can take that into consideration for conditions. We can always impose reasonable conditions on any planning application. And a lot of the information comes out from those public hearings.
Well, Kori, thank you so much for joining us today. It's always a pleasure to work with you, and all of the valuable insights that you provide here to our city help us to do a much better job on behalf of everyone. So thank you so much.
You're welcome. Thanks for having me.
The process under which members of the Planning Commission, Economic Development Authority, and City Council must work is guided by state law, regulations, and the city's zoning requirements, which are further approved by the Metropolitan Council. We hope this conversation helps provide some clarity around the legal process as it relates to residential and commercial development. For Council Update, I'm City Council Member Steve Dennis.